All rise, veuillez vous lever. Please be seated, veuillez vous asseoir.
Mr. Archie, it should be said that we're still maybe not entirely clear of how you're going to put this on the balance of probabilities, but I think we'll wait and see as you develop your argument.
Mr. Ian Edwards will come back on this issue tomorrow. May I, Madam President?
Yes, you may. I'm sorry, yes.
Thank you. Madam President, honorable judges, dear colleagues in the courtroom, public in the gallery, and at large following this hearing, particularly in Sudan and in neighboring countries. The defense will intervene today in reply to the written submissions of the Office of the Prosecutor and the legal representative of victims. The reply to the oral submissions made today by the legal representative of victims will be addressed tomorrow after witness D16's appearance and with the defense final submissions. On 6 October 2025, Trial Chamber 1 found my client, Mr. Abd-Al-Rahman, guilty of all crimes described in the charges. These crimes were committed in Kodum and Bindisi in August 2003 and in Mukjar and Delej in February and March 2004. The judgment issued by the trial chamber on that day is historical. As highlighted by Madam President Corner in a public reading of the summary of the judgment on 6 October, this is the first time an ICC case in relation to the situation in Darfur reaches the point where a trial is concluded and a judgment is issued. It is also the first time Resolution 1593 of the UN Security Council results in the issuance of a trial judgment. Actually, this judgment is the first judgment ever issued on the basis of a referral by the UN Security Council. Most importantly, it is the first judgment with respect to crimes committed in Darfur and illustrating the sufferings of the victims. For all these reasons, the 6th October 2025 is and will remain a milestone in the advance of international criminal justice and for the ICC. Whatever its outcome, the appeal lodged by Mr. Abd-Al-Rahman neither aims nor does undermine the symbolic importance of the 6th October 2025 judgment. Although it is too early to fully apprehend the scope of the appeal, what matters is that it focused on the findings of the Chamber on the role played by Mr. Abd-Al-Rahman, without questioning the materiality of the events that took place in Kodum and Bindisi or in Mukjar and Delej. As you know, the defense has never challenged the occurrence of these events, your factual findings on the materiality of these events are not challenged, they are final. The finality of your factual findings on the events of Kodum and Bindisi, Mukjar and Delej, as far as they do not relate to Mr. Abd-Al-Rahman's role in these, provides the background of the present hearing. Whatever the outcome of the judicial debates that we have this week, and the sentence that your chamber may decide to apply to Mr. Abd-Al-Rahman, the victims can be reassured. Their suffering has been acknowledged. It is not and will not be challenged during this hearing. The acknowledgement of their suffering also paves the way to reparation proceedings. At last, the condition of conviction of the accused under Article 75, paragraph 2 of the statute has now been satisfied. Should the conviction get overturned in appeal, the defense will request and insist that victims be afforded reparations nevertheless. Article 75(2) does not require conviction to be final. The evidence on record shows beyond any reasonable doubt that Mr. Abd-Al-Rahman has no financial capacity to contribute to the reparations. The award for reparations will thus have to be made through the Trust Fund for the Victims, pursuant to the second sentence of Article 75, paragraph 2, and there is thus no reason why an eventual acquittal by the appeals chamber should prevent or stop reparation from happening. The victims can trust that the defense will insist for reparations to happen. For the same reason, after this hearing, the defense intends to move your trial chamber to open reparation proceedings without waiting for the outcome of the appeal. You have found Mr. Abd-Al-Rahman guilty. This finding fulfills the condition under Article 75, paragraph 2. The victims are waiting for any significant reparations to happen. The award will have to go through the trust fund. There is no reason why they should wait further the outcome of the appeal. So your judgment of 6 October 2025 is also historical, Your Honors, because it paves the way to the first ever reparations for victims in Darfur. For all the reasons I mentioned, our debate of this week on the sentence that Mr. Abd-Al-Rahman should get can have no impact on the historical dimension of your judgment of 6 October 2025. This week, we are talking about something else, something totally different. We are not talking about the materiality of the crimes committed in Kodum, Bindisi, Mukjar, and Delej. For the first time also, we are not even talking about the guilt or innocence of Mr. Abd-Al-Rahman for these crimes. These are not discussed in this courtroom, and nothing that the defense will say can be construed as an admission of Mr. Abd-Al-Rahman's guilt or with respect to any of the issues raised in appeal. Our submissions are based on your findings of 6 October 2025 without prejudice to Mr. Abd-Al-Rahman's right to challenge these in appeal. Your findings regarding Mr. Abd-Al-Rahman's guilt are thus the premise of the defense submissions during this hearing. The only possible bridge between this week's discussion and reparations for victims could have been if victims had claimed retribution against Mr. Abd-Al-Rahman. We can all appreciate the immense dignity of the victims through the views and concerns reported in the written submissions of the legal representative of the victims on sentencing. With your permission, I will quote for the public to measure it. Paragraph 16 of the LRV submission, I quote, "The participating victims in this case have unequivocally expressed their strong desire for accountability and justice, as well as peace and restoration, but no vengeance." I stop here. Accountability and justice, no vengeance. I quote again. "The participating victims have vested considerable confidence in the trial chamber and trusting the judge's experience to determine the appropriate sentence to be imposed upon Mr. Abd-Al-Rahman." End of quote. A judicial determination based on applicable law, not a call for blind retribution. Paragraph 24, I quote, "My right is to say what I feel, but for the judgment, for the sentencing, that belongs to the judges." End of quote. A judicial determination, again, based on law, despite all emotions expressed by the individual victim. Last quote, paragraph 27. "Although I am in favor that he receives a punishment, I do not know what kind of punishment I can suggest. We know what we could do, but I know it would not be fair. This is why we leave it to the judges to do their work and decide the appropriate sentence." End of quote. Beyond the pulsion of retribution, the conviction that it is not fair, and the deferral to the application of the law. The rare victims who claim a life sentence for Mr. Abd-Al-Rahman do so out of fear for his return to Sudan and his resumption of criminal activity. I quote from paragraph 21. "If he comes, he will start again and commit crimes. If he comes back to Sudan, I think he will start planning for other crimes. He will create new problems. But the respectable fears expressed by the participating victims are omitting a key factor. Mr. Abd-Al-Rahman is 76 years old. His health is not good. Even if he wanted, there is no chance that he may resume participation in warfare, even less so in criminal activities. We respect the expression of that fear, but it is immaterial and shall be considered so. Mr. Ian Edwards will come back on this tomorrow. The views and concerns of the participating victims are unequivocal on the fact that, despite all their legitimate emotions, what they want, what they are expecting from you, your honors, is the fair application of the law. Nothing else, and it is your legal expertise that is looked after. No emotions, no concern for the public's perceptions or expectations. The public, in its vast majority, and I say so with all due respect, is ignorant of the law. The participating victims have the remarkable humility of admitting so. The public is discovering terrible facts from your findings and says, oh, that's serious. It deserves a heavy penalty. This is not a reaction that is based on law. It is a reaction based on emotions. And when you hear about rapes, tortures, murders, of course it is serious. That is public opinion. But the law is something entirely different. It may, in some circumstances, converge with public opinion and reach to the same conclusion. But sometimes, the fair application of the law leads to a totally different result. And when that is your honors, your mandate is to follow the law and disregard public opinion. This court is not a popular tribunal. It is a court of law. It is the International Criminal Court, established by a statute adopted in 1998 in Rome by a vast majority of states of the world. The advent of this court has been awaited too long in the history of humanity. World War I and World War II, with their procession of horrors, ended without such a court. In Nuremberg and Tokyo, the nations improvised ex post facto international military tribunals to fill that gap. As early as 1948, the Convention on the Prevention and Repression of Genocide called for the establishment of this court. It took 50 years, many wars and atrocities all around the world, and the creation of other ex post facto international tribunals until the statute of this court was eventually adopted in Rome. From its preamble, the state parties recall that they are, I quote, resolved to guarantee lasting respect for and the enforcement of international justice. International justice, not vengeance. For the first time in the history of international criminal justice, this court was equipped with a robust section enunciating the general principles of criminal law. The section starts with the following three general principles: nullium crimen sine lege, Article 22, nullia pena sine lege, Article 23, and non-retroactivity ratione personae, Article 24. These are the first and most fundamental general principles of criminal law that apply before this court. At paragraph 84 of its judgment OA8 in the present case, the appeals chamber commented, I quote, "Scholars describe the prohibition of retroactive criminal laws as a fundamental and non-derogable rule of international law, and some suggest it has attained the level of a jus cogens norm." End of quote. These non-derogable principles are enshrined in the statute of this court. These form part of the law that you, your honors, are called upon to enforce. These principles are protecting essential values, In concrete terms, they mean that no one can be found guilty and punished of his acts. I start again. No one can be found guilty and punished if his acts were not criminalized and the applicable penalty was not provided in the law that was applicable to him at the time of his actions. It also means that no harsher penalty shall be imposed upon a person on the basis of a subsequent change in the law that applies to him. Disregarding these fundamental guarantees, taking more liberty with the values they protect than international body in charge of protecting human rights, I'm talking about the European Court of Human Rights, the African Court of Human and People's Rights, and the Inter-American Court of Human Rights unanimously do, this would constitute no less than a violation of the Court's values and, with all due respect, of your mandate as judges of this eminent court. The states which have established this court, the public at large, eager to see it uphold the highest standards of fair justice, and even the participating victims who have suffered and still suffer from the consequences of the crimes committed in Darfur are unanimously expecting you to give full resonance to these fundamental principles. This court, the International Criminal Court, is a beacon of international justice. As such, the weight, substance, and effectivity that it will give to the most fundamental principles of criminal justice, such as nolium crimen, nullia pena sine lege, and the non-retroactivity ratione personae of criminal law, will guide all nations throughout the world in the evolution of their own law. Disregard these fundamental principles, and this will encourage the most authoritarian, non-democratic, and most repressive systems of the world, like Sudan in 2003 and 2004, to empty those principles and violate them. People throughout the world will be prosecuted and punished on the basis of acts which did not even constitute an offense at the time of their action, and they will receive harsher sentences than those in place at that time. Should this court disregard, empty, or nuance these fundamental principles at the time of applying them to Mr. Abd-Al-Rahman, it would become no more than what it aims at preventing and repressing in this case. This is not the court that human rights defenders want. This is not the court that the victims of the crimes in Sudan tell you through their legal representative that they want. This is not the court that I want, and this is not, I have no doubt, the court that you want, Your Honors. Peoples around the world, victims in Sudan, and most certainly in the first place, you, Your Honors, want the International Criminal Court to be a court of law, the beacon of international criminal justice and fair trial. So let it be. I have full trust that under the authority of Your Honors, this court of law will enforce the law, even when it diverges from public opinion. Grave crimes incur serious penalties, says public opinion. Grave crimes incur the fair sentence that applied to the offender at the time of his actions, says the law. The victims, through the views and concerns they expressed in the legal representative submissions, show that they are perfectly aware of where the public opinion leads to. and that they have also expressed so themselves. But what they have also expressed is that what they are calling for is low. This is what they are expecting from your owners. In its written submissions, the Office of the Prosecutor is not looking at the law. The Office of the Prosecutor is directly diving into the factual findings made in your trial judgment to insist again and again on how serious the crimes are. This is done without addressing the applicable legal framework, without identifying the law applicable to Mr. Abd-Al-Rahman in 2003 and 2004, without providing any legal reference as to penalties that may apply to him. It's all about facts and emotions, not about law. On facts and emotions, the Office of the Prosecutor is certainly much less legitimate than the victims to express an opinion. The victims clearly express their views and concerns. The Office of the Prosecutor's only concern is to get the heaviest sentence possible for Mr. Abd-Al-Rahman, hence their insistence on the seriousness of the offenses. They ask you to impose a life sentence as a hunting trophy. Turning to law, there is nothing in the prosecution submissions. They had a full opportunity to ground their claim for life sentence on a solid analysis of the applicable law. Look at the law in force at that time in Sudan. Compare, as far as such comparison would have bear relevance, with the practice of sister international tribunals, or even the case law of this court, applicable pursuant to Article 21, paragraph 2 of the statute. They don't. They took full advantage of the extension of page limits granted at the request of the defense without touching the law. It actually looks like when it's about penalties, the prosecution suddenly becomes allergic to law. The prosecution tried in vain to oppose the reappearance of witness D16 and the admission of his new written statement. The defense had solicited it for the precise goal of assisting your chamber in its determination on the applicable Sudanese law in 2003 and 2004. The prosecution argued that Sudanese law was irrelevant and that it was not the role of witness D16 to tell you the sentence that Mr. Abd-Al-Rahman should get. The defense never suggested, will never suggest, that witness D16's evidence about the law applicable in Sudan in 2003 and 2004 should dictate your sentencing judgment. You are the judges. You alone, not witness D16. And if my perception of his humility is correct, he would never claim so. Witness D16 will appear tomorrow to assist your chamber by providing information on the state of the law in Sudan in 2003 and 2004. The defense admits that this is a relevant information for a variety of reasons. In the first place, the application of Article 24, paragraph 2 of the statute, according to which, in the event of a change in the law applicable to a given case prior to final judgment, the law more favorable to the person being investigated, prosecuted, or convicted shall apply. Based on its purely subjective, falsely emotional, never legal submissions, the prosecution concludes every section of its written submissions by proposing a penalty. Again, no legal justification come in support of its wet finger proposals. To look at these, the defense has prepared a chart comparing OTP proposals with D16's evidence on applicable sentences under Sudanese law. Of course, in order to avoid wasting the court's time, only the penalties provided under Sudanese law which are compatible with the Rome Statute, especially its Article 23, nulla pena sine lege, are considered here. And because the OTP's proposals are related to imprisonment sentences, its proposals are compared with the equivalent imprisonment sentences applicable in Sudan in 2003 and 2004. Ça vient?
Screen's gone blank.
Oh, I was expecting the chart to appear on the screen, but... it's on... okay. I'm told that it is on your screen. So I can carry on? Okay. As you can see in this chart, and I hope the public can see it, in the left column, OTP proposals run from 5 to 30 years imprisonment, depending on the counts. In the right column, witness D16's evidence run from 6 months to a maximum of 30 years. It is relevant to note that with the sole exception of count 1, the penalties, here it is. The penalties applicable under Sudanese law are the most lenient compared to the penalties under ICC law proposed by the Office of the Prosecutor. The only exception is count 1, for which OTP proposal of a term of 14 years is more lenient than the penalty for a term of 30 years applicable under Sudanese law, according to witness D16's written statement. I will come back to that comparison in my final pleadings tomorrow. What matters at this stage, in reply to OTP's written submission, is that the proposed penalties under each count are not supported by any legal basis, but the result of a simple and subjective assessment of gravity made by the Office of the Prosecutor on the basis of your factual findings. These in no way can be considered a proper justification for a proposal of penalty, even less so the heaviest and most exceptional penalty of life sentence under Article 77(1)(b) of the statute.
Mr. Lurchie, to be fair to you, there is a question that arises as a result. Would you prefer that I stop you and ask you the question, or wait until the end as I've done with the others? It's entirely up to you, because I know otherwise it interrupts.
I would have said that it is entirely up to you. Maybe you can ask, and if I address it, that may be my response. Later, that may be my response. If not, I may try to answer your question immediately or come back to it. I don't know. Your preference.
All right. Is it your contention then that the prosecution should have indicated by reference really to other ICC cases or ICY or whatever? But isn't the general principle that no two cases are the same? The factual matrix is usually different, and it's why it's never been possible, as I understand it, or attempted, to produce some sort of sentencing guidelines for international courts. So, but I just want to know, are you saying they should have actually listed cases?
The principle that you mentioned, Madam President, is perfectly correct, and I'm certainly not the one who will challenge it. But once again, when you make a proposal in law, you try to rely and to support it by some legal basis. That's what we do in our daily work, and I don't see how penalties should be an exception to this exercise.
Yeah.
The individual specialty of the case, this in the end is your determination. But when we ask you that, when we tell you this offense calls for this sentence, well, I'm sure you would appreciate to have some legal basis in support of this allegation, exactly as the same as, well, we have been working together for, what is it now, 3, 4 years? I don't remember, but 3 years, let's say. Well, you never received a submission from the defense, or even from the prosecution, actually, except on penalties, that was not supported by some legal basis.
Okay, thank you. Sorry, Mr. Archie.
You're welcome.
I think what I'll do, actually, I will leave any questions I watch to the end so I don't interrupt your flow.
Your preference. Under Article 77(1)(b) of the statute, the term of life imprisonment is reserved for cases where, 1, the extreme gravity of the crime, and 2, the personal circumstances of the convicts justify so. The travaux préparatoires on what became Article 77(1)(b) point to the special significance of the reference to extreme gravity with reference to life imprisonment. The words were added as part of a delicate compromise aimed at winning the agreement of some states for whom life imprisonment was deemed to be cruel, inhuman, and degrading treatment or punishment. The possibility of life imprisonment was included in the Rome Statute on the assumption that its imposition would be extremely rare, even with the rather limited universe, within the rather limited universe of prosecution by the International Criminal Court. The exceptional nature of life imprisonment at the ICC creates a presumption in favor of a fixed term of imprisonment to a maximum of 30 years under Article 77(1)(a). At paragraph 167 of its written submissions, the Office of the Prosecutor, after having proposed sentences running up to 30 years for individual counts, simply concludes that the appropriate joint sentence in this case is a term of life imprisonment. End of quote. No justification other than its subjective assessment of the gravity of the crimes, no legal analysis of the sentencing practice of this court, no reference to the travaux préparatoires, no legal basis supporting that joint sentence, no case law, nothing to justify crossing the abyssal gap set by the negotiator of the Rome Statute between its Article 77(1)(a) and its Article 77(1)(b). No ground for reversing the presumption of fixed-term imprisonment under Article 77(1)(a). Only one sentence, I quote, "The Chamber must impose a joint sentence which is no less than the highest individual sentence pronounced." End of quote. If the joint sentence indeed cannot be less than the highest individual sentence, pursuant to Article 78, paragraph 3 of the statute, it is not necessarily higher. But the prosecution does not explain why the Chamber should go higher than the highest individual sentence it recommends in its written submissions. The prosecution further errs in law when it submits that a joint sentence imposed on the basis of individual sentences not exceeding a term of 30 years can be a term of life sentence under Article 77(1)(b). To be imposed, a term of life imprisonment must be justified by, I quote, the extreme gravity of the crime. The crime is singular, not plural. The proper reading of Article 77(1)(b) means that to impose a term of life sentence, the chamber must find at least one individual crime for which the person is convicted, which reaches the level of extreme gravity, justifying the imposition of a term of life imprisonment. At least one crime of extreme gravity. Life imprisonment cannot be imposed as a joint sentence for individual crimes which individually do not fulfill the threshold of extreme gravity under Article 77(1)(b). The travaux préparatoires on Article 78, paragraph 3 reveal that this article is the result of a compromise, again, between two different approaches to sentencing. The first approach consisted in imposing one single joint sentence for all crimes the person was convicted for, and in that case, life sentence could be imposed whenever the gravity of all crimes together, plural, reached the extreme gravity threshold. This is, in substance, what the Office of the Prosecutor is suggesting at paragraph 167. This solution was not followed in Rome. The second approach consisted in imposing a distinct sentence for each individual crime the person was convicted for, and to state whether these would be served consecutively or concurrently. Under that approach, one term plus another could never reach a term of life imprisonment unless at least one of the individual sentences imposed was itself a life imprisonment sentence. Although the option of serving the various individual imprisonment terms consecutively was abandoned because it would have resulted too easily in a de facto term of life imprisonment, which had to remain exceptional, the final compromise of Article 78, paragraph 3 is closer to this second approach. No life imprisonment unless one of the individual sentences in concur is itself a term of life imprisonment. In Rome, the coordinator of the working group on penalties proposed the following, I quote, "When a person has been convicted of more than one crime, the court shall indicate a sentence for each crime and pronounced on the total period of imprisonment to be served, which shall not exceed half of the longest term of imprisonment prescribed for the gravest crime." That's UN Doc A/conf.183/C.1/WGP/L.9. Even if you follow the proposal of 30 years for some of the crimes, and of course the defense will strongly rebut this proposal of 30 years. One and a half times 30 years makes a total of 45 years, which is not possible under Article 77(1)(a), but it does not make a life imprisonment under Article 77(1)(b). My reading of Article 77(1)(b) and 78(3) is confirmed by all commentators to the Rome Statute, In Trifterer, Mark Jennings takes the example of 5 separate sentences of 20 years imprisonment for which the joint sentence may be no less than 20 years and may go up to 30 years, not life. The same in Chabas' commentary, the same in Cassese Gaeta Jones, and the same in the French commentary by Damien Scalia. Against the travaux préparatoires, against all commentators of the Rome Statute, without any legal basis to support its claim, the OTP recommended individual sentence going up to 30 years and a joint sentence of life. This is not what the victims called for. The victims called for the law. There is no law in OTP submissions. According to law, and specifically Article 78, paragraph 3 of the statute, should the chamber follow the OTP and disregard mitigating circumstances, the joint sentence can be no less than 30 years, but it cannot be more pursuant to Article 77(1)(a), and it cannot be a life sentence pursuant to Article 77(1)(b), because none of the individual offenses reach this exceptional threshold, according to the OTP itself. I now move to the two cumulative criteria of extreme gravity and personal circumstances under Article 77(1)(b) of the statute. We will see that, as admitted by the prosecutor in its written submissions, neither the first nor the second are met by any of the individual counts in the present case. The extreme gravity of the crime can be difficult to handle with respect to crimes under the jurisdiction of this court. Under the preamble, they all fall within the category of the most serious crimes of concern to the international community as a whole. Nuances exist, though. Some crimes are objectively and manifestly more serious than others. The first that comes to mind is obviously the crime of genocide under Article 6 of the statute, characterized by the intent to destroy a group in whole or in part. Its exceptional gravity is confirmed by the high number of life imprisonment sentences issued by the ICTR or the Tribunal for Cambodia. In the genocide cases, the question about sentencing was whether there were good reasons not to impose life sentence. But there is no genocide in this case. The second crime that comes to mind is the crime of aggression under Article 8 bis of the statute. Its ancestor, the crime against peace, was rightfully labeled as the crime of crimes in Nuremberg because it contained them all. Again, no crime of aggression in this case. Extermination as a crime against humanity under Article 7(1)(b) of the statute is certainly another crime of extreme gravity. Before the ICTY, extermination was punished by life sentence in first instance in the Stakic case. The sentence was later reduced to 40 years by the appeals chamber. That's case IT 9724. And also in the Lukic case, case IT 9832/1. But once again, no extermination in this case. The fact that other crimes not reaching the threshold of the above crimes of an extreme gravity have been committed as part of a widespread or systematic attack against the civilian population is a common element to the crimes against humanity under Article 7. It's not elevating these other crimes, like murder or persecution, to the level of crimes of an exceptional gravity for the purpose of Article 77(1)(b). If the office of the prosecutor wanted Mr. Abd-Al-Rahman to be sentenced for life, it should have prosecuted him for genocide or extermination. The OTP did not. They cannot call for the imposition of a term of life imprisonment on the basis of his conviction for other crimes. Among the individual crimes for which the OTP claims the highest sentence of 30 years imprisonment in its written submission is the crime of persecution under counts 11, 21, and 31. The OTP has no case law on which to rely to justify the alleged exceptional gravity of this particular crime. And the reason for that is that there is none. The OTP is actually asking the chamber to be innovative and to decide that, I quote from paragraph 73 and 136, the intersecting nature of the grounds for discrimination demonstrates the compounded and thus heightened gravity of the crime of persecution in this case. End of quote. The only legal reference on which the OTP relies to support this alleged heightened gravity based on intersectionality is paragraph 787 of your trial judgment, where you observed that, I quote, a victim can suffer a higher risk of victimization because of the intersection of different factors of discrimination. End of quote. But a higher risk has nothing to do with the gravity of a crime. The higher risk is about heightened probability of being victimized, but it has nothing to do with the gravity of the victimization. Being discriminated on ethnic ground is neither less nor more serious than being discriminated on politic or gender ground, nor than being discriminated on the basis of a combination of more than one of these grounds. The probability of being targeted if you were a man, a Four, and a supporter of the rebellion was obviously higher than if you were an Arab woman supporting the government. But this had nothing to do with the gravity of the discrimination that you may be exposed to. Innovations in international judgments can contribute to the development of international criminal law. But these must be solidly grounded. We have nothing such in the prosecution's written submissions. No legal reference, no domestic practice, no international case law, nothing. What the prosecution is asking you, your honors, in nothing less than making up a new rule according to which the higher the number of discriminating factors, the higher the gravity of discrimination. Your honors will remember the women victims and witnesses who appeared in this case. I'm talking about P11, P15, P1073, P1074, V47P1, and V47P5. All remarkable, full women, full of dignity, who had never been involved in politics, who came and testified about the torment they had suffered. But what the OTP theory on intersectionality is telling to these wonderful, full women not involved in politics is that the persecution that they endured was not so grave, at least less grave than the persecution endured by full men supporting the rebellion. This is simply not acceptable. and for the sake of all people who endure discrimination and persecution around the world for the sole and unique reason of their either political, racial, national, ethnic, cultural, religious, or gender affiliation, I solemnly ask you not to follow OTP's dangerous theories on intersectionality as an aggravating factor. Persecution is a serious crime, obviously, as all crimes under the jurisdiction of this court. But it cannot form the basis for the imposition of a term of life imprisonment under Article 77(1)b, and the prosecution knows this very well because they are not even requesting so. Murder is the other crime for which the prosecution proposes a term of 30 years imprisonment. The crimes of murder is certainly a serious crime, a serious one, impacting the life of protected persons is certainly more serious than other crimes against property, for example. But this does not qualify murder as a crime of extreme gravity like genocide, aggression, and extermination under Article 77(1)b for the purpose of imposing a term of life imprisonment. The OTP provides no legal basis, no case law in support of its submissions. Murder has been prosecuted before all international criminal tribunals. It has never reached the imposition of a term of life imprisonment unless it was committed in combination with the extremely serious crimes of genocide or extermination, or when the personal circumstances of the convicts justified so. Despite its objective gravity, murder does not reach the threshold of extreme gravity under Article 77(1)b. I turn to the second factor, the personal circumstances. Rule 145, paragraph 1b provides that your chamber shall balance all relevant factors, including any mitigating and aggravating factors, and consider circumstances both of the convicted person and of the crime. Outside the cases of conviction for the most severe crimes of genocide and extermination mentioned earlier, the instances of life sentence are very few in international criminal justice, and they always find their justification in some particular personal circumstances of the convict, rendering his case exceptional even when the crimes were not. Before the ICTY, Galich was sentenced to life imprisonment without being convicted for genocide or extermination. Galich was a general. He was the commander of the Sarajevo-Romania Corps, and he was the third in command in the VRS, immediately after its supreme commander, Radovan Karadzic, and his chief of staff, General Ratko Mladic. In the Sudanese context, Galic's position would have corresponded to a, Madam President, there is something that is itching you.
Obviously, you know, it's something I know, but I don't think you've got it right. Mladic wasn't the chief of staff.
Oh, I read so in one judgment, may have been an error, but...
No, Mladic was in command of the whole VRS. If he'd just been a chief of staff, then he wouldn't have had any command responsibility.
Thank you for this clarification. And that's important for the record of international criminal justice. So, Galich, in the Sudanese context, His position would have corresponded to a position coming just after President Omar al-Bashir and Vice President Ali Osman Taha in the Sudanese government. It is far, far above the highest rank your honors have found Mr. Abd-Al-Rahman was encumbering in 2003 and 2004 in the trial judgment. That is the position of a local Janjaweed leader in the small sub-region of Wadi Saleh, with no de jure authority and, at worst, a de facto authority on an unidentified number of people for which, I'm quoting paragraph 983 of your judgment, the evidence does not clearly reveal why a retired Musaid in the medical corps of the SAF, who became a pharmacist, should have achieved such a position in the area, end of quote. Nothing comparable to General Galich, nothing fulfilling the criterion for life sentence under Article 77(1)(b). Prior to following the unsubstantiated, unsupported requisition of the OTP, your honors, you will have to consider the case of Mr. Abd-Al-Rahman in the wider context of other cases in the Darfur situation. Al-Bashir, Hussein, and Harun remain at large. They encumbered much higher positions in the government of Sudan. If a small local Janjaweed leader with an unclear basis of authority gets sentenced to life imprisonment, what will the court be left regarding these other cases? Would that mean that these other defendants shall automatically expect life imprisonment for the court? Or would that mean that this court punishes more severely small fishes like Mr. Abd-Al-Rahman than the highest authority of the country in command at the time of the crimes? Those who have decided that the crimes would be committed and who have ordered them to be committed. What kind of message would deliver the court if it was so? How compliant would that be? Would that message be with the court's mandate of accommodating accountability with fair justice? The message cast would be wrong. Absent any other guidance, your honor may, pursuant to Article 21, paragraph 2 of the statute, turn to the principles and rules on sentencing as interpreted in the court's previous decisions, as far as these are relevant to the present Sudanese context, of course. The Office of the Prosecutor, once again, does not say a word about it in its submissions in support of its request for life imprisonment. And we understand why. Thomas Lubanga Diallo held the position of Commander-in-Chief in the UPC FPLC and National Secretary for Defense, quoting paragraph 1142 of his trial judgment. His position was much higher than the position your honors found Mr. Abd-Al-Rahman held. His de jure and de facto authority was clearly established. He was sentenced to 14 years imprisonment, upheld in appeal. Germain Katanga held the position of President of the Combatants. I'm quoting trial judgment, paragraph 1246. His position was again much higher. His de jure and de facto authority was clearly established. He was sentenced to 12 years imprisonment. Bosco Ntaganda was the Deputy Chief of Staff of Thomas Lubanga Diallo, second in command in the UPC FPLC. Again, much higher, with clearly established de jure and de facto authority. The trial chamber identified about 10,000 victims in its reparation order. He was sentenced to 30 years imprisonment, upheld in appeal. Dominique Ongwen held initially a rank of major, that is, between a captain and a colonel. And he was promoted colonel and then brigadier. I'm quoting from paragraph 1013 to 1016 and 1078 to 1083. All these ranks are much higher than the highest rank of Musaid Mr. Abd-Al-Rahman ever occupied. The trial chamber, in its reparation order, identified about 50,000 victims. He was sentenced for a term of 25 years imprisonment, upheld in appeal. Al-Hassan was the commissioner of the Islamic police. Trial judgment, paragraph 1063, 1065. A much higher position again, with clear de jure and de facto authority. He was sentenced for a term of 10 years. Alfred Yekatom was a leader of a group of anti-Balaka, that's trial judgment, paragraph 63, and an elected member of the Car Parliament, that's paragraph 4474 of the trial judgment. Although the position of leader of a group of anti-Balaka may be compared to the position of Janjaweed leader held by Mr. Abd-Al-Rahman according to the trial judgment, being an elected member of parliament conferred to Alfred Yekatom a much higher de facto authority than the authority of a Janjaweed leader. He was sentenced for a term of 15 years imprisonment. And finally, Edouard Ngaisona was also a member of parliament, paragraph 896 of the trial judgment, and he was the general coordinator for all anti-Balaka in Central African Republic, that's trial judgment, paragraph 60 to 62. This was a much higher position with higher de jure and de facto authority than Mr. Alfred Yekatom and the authority that your chamber found Mr. Abd-Al-Rahman had. He was sentenced for a term of 12 years. None of the ICC case so far support the prosecution proposals for a term of life imprisonment for Mr. Abd-Al-Rahman. Convicts encumbering much higher positions with much higher and clearer de jure and or de facto authority were sentenced for terms of a specified number of years ranging from 10 to 30. The lower convicts, like Mr. Germain Katanga, Al-Hassan, or Alfred Yekatom, were sentenced to terms ranging from 10 to 15 years. The number of victims identified in your trial judgment, or the number of represented victims, 1,592 in this case, are much lower than the numbers that I already mentioned for the Ntaganda case, more or less 10,000 direct victims, or the Ongwen case, more or less 50,000 according to the reparation orders. The number recently communicated by the VPRS in its mapping obviously cannot be used as reference by your owners in your sentencing judgment. These numbers have not been verified, have not been submitted to a judicial debate. The only numbers that your owners can consider are those mentioned in the trial judgment or the number of represented victims. Should your owners wish to rely on this court's previous decisions as applicable law under Article 21, paragraph 2 of the statute, the personal circumstances of Mr. Abd-Al-Rahman, namely his position and authority, should, according to your trial judgment, be found within this window of 10 to 15 years maximum, no more. This is, of course, without prejudice to the defense submissions on applicable law that will be exposed on Wednesday after witness D16's appearance, and without prejudice to Mr. Abd-Al-Rahman mitigating circumstances. The defense has advanced no less than 12 mitigating circumstances in its written submission. I do not repeat these here. In its written submissions on sentencing, the Office of the Prosecutor addresses some of these. My colleague Yen Edwards will respond to the OTP on most of these, and I will myself address the mitigating circumstance with respect to Mr. Abd-Al-Rahman's words and actions in favor of victims. The defense will not address further its mitigating circumstances A, B, I, and L, which have not been challenged by the prosecution in its written submissions on sentencing. We refer to our written submissions on these. We may simply add some additional observations in reply on Wednesday, in reply to the oral arguments of OTP and of the LRVs today.
I'm going to interrupt. I'm sorry, what are you talking about? In your sentencing brief,
Yes.
A is purpose of sentencing, B is sentencing principles. Is that what you're referring to?
I will stop looking great and I will put the... Please, Madam President.
It's from page 9 in the brief, Your Honour. It's that little a.
Oh, I see. The mitigate I see is under the mitigating. So you're not covering. Say again.
In this oral submission, that is the first one, the first round, we do not cover, what did I say, A, B, I, and L, because there were no written submissions on these. We may add some words in reply on Wednesday, if necessary. But that will be in reply of the oral submissions. Madam President, I have an eye on the watch. Initially, what we have planned is that I would stop here and leave the floor to Mr. Yen Edwards to start with the mitigating circumstances, and then I would come back at the end with the last one on victims. Maybe a more efficient way would be, just too bad for the order, for me to cover the victims now, and Mr. Yen Edwards can start tomorrow with the other mitigating circumstances, if that works.
Well, do you want, given the difficulties of your witness, have you arranged for him to appear first thing tomorrow morning?
Well, he is in the end of VWU.
Because, I mean, it doesn't seem to me that it'd be a good idea to keep him waiting one way or another. So if it's been...
Oh, well, I may be wrong, but I don't have this perception. I mean, I cannot say what was the issue, but the issue that triggered your summons is resolved.
Yeah.
It is where he will appear from, and he is available. Now, be it at 9:30 our time or 11:30, I don't know. It may be nicer to him to hear him at 9:30, and then we will restart the oral submissions, the first round, the end of the first round of oral submissions after him. Up to you.
It does seem to me that it's more sensible if we fix the time now for when it be heard. I'm in the hands of the court officer as to whether it's preferable for 9:30 or 11:30.
If I may suggest something, if court officer have a possibility to send a quick email to VW and check, that could provide the best answer.
Right. Yeah.
8h30.
Okay. Okay, I think it's probably more sensible then. Apparently, he has to be refamiliarized. Why, I'm not sure. So it'd probably be better 11:30 than after the break. 9. Oh, sorry, 9. Oh, sorry, 9. No, I'm being corrected. Better 9:30, I'm told. Yeah.
Very well. So we will complete our first round of submissions after his appearance.
Well, can you deal with the victims in 10 minutes? If not, we'll leave that till tomorrow.
It's a bit short.
All right. We'll leave that. Okay, well then, can I just... you addressed it at some length on I think it was Article 24.2, which is the nulle criminal, whatever it is. On which we've ruled on that. I mean, we've said, so there's no point. So your address on that, I'm not quite clear what it was aiming at.
Your judgment dealt with the application of the principle nolium crimen sine lege.
Exactly. Thank you.
The submissions that on sentencing that I intend to make on Wednesday is related to not to Article 22 nolium crimen, but on Article 24, more specifically 24 paragraph 2, and that's the non-retroactivity ratione personae, in particular with respect to sentencing.
Right.
And
okay. Yeah. I'm sorry. Yes, I've got it. I've written down Article 24, but I thought you were further addressing us on the Article 22.
No.
Yes. Right.
My time is too short and too precious to lose time with that, Your Honor.
Yes. All right. Okay. Oh, that's fine then. In that case, we will leave that and just checking to see whether any other questions, any matters already covered. Yes, I may come back to what you submit about him being a local leader, but I'll wait until the end. Yes. All right. In that case, we'll adjourn until tomorrow at 9:30.
All rise, ve voleve.